He clowned himself because he was asking her, how is it that she could oppose felons having the right to vote, but yet she would want to restore the rights of nonviolent felons, their Second Amendment rights. And he did not realize, and he wasn't saying, I don't believe in my heart that his line of questioning on this was ignorant. He really, I think, is clueless on this. And it's because voting isn't a natural right. I know people are shocked when they hear this because this needs to be taught more in depth in all levels of education. This is the difference, and this is why I'm very careful and I correct people when they use the phrase civil rights as opposed to natural rights. I've even had people, regular listeners, that have written me and have criticized me for saying natural rights when I should say civil rights. And I'm like, no, what you're doing is reducing the status of our rights. Civil rights are rights that have been created in a court by man for man. Natural rights are rights that we have, and they are affirmed in the Constitution, our founding document, which clearly stipulates that these rights are free from government intervention. No court created by man. Now, it does leave certain powers to the states, Article 1, Section 8. But there is a huge disconnect here. And never before have I been so interested in an exchange during a Supreme Court hearing just for a purely at an academic level, not because there were fireworks and controversy, but because this has opened up, I think, a huge issue that has been long debated, but not really delved into in the country. And my point was this also. Like, he's grilling her, and the case in question was Cantor v. Barr. And I've read it. It's a 37-page opinion, and it authored by Amy Coney Barrett. And it had to do in a case of a guy who, to keep it short, because we're going to dive into this next hour, it had to do with the case of a guy who was convicted of a nonviolent felony. I mean, essentially, he was representing a product as being approved by a certain government entity when it was not approved by a certain government entity, and that constituted fraud. Thus, his punishment was that he was felonious. His crime was considered felonious in nature, and as a result of his punishment, he was declared to be a prohibited possessor. And in the issue at hand was whether or not, and she cited precedents for this too, whether or not his rights, his natural rights as affirmed by the Constitution, I'm not talking about civil rights created in a court or codified by state statute, but whether or not his rights could actually be eliminated and controlled by the federal government. And that is what her opinion struck at the heart at. It was about, what is the litmus test for rescinding someone's natural rights? And even going back to the times of the colonies, it had to do with whether or not that person constituted a threat to public safety. And that was the basis on which someone was deprived of the right of Second Amendment or firearm possession. And different colonies had different regulations, etc. And so her opinion is brilliant. It is brilliantly nuanced. She is one, and regardless of whether or not you agree with her, you should do yourself the favor and give your mind a treat and read it. Everyone loves to talk about this stuff, and everyone loves going on and on and on about their government, but how many people are willing to put aside the time to actually get involved and read some of the stuff that is being discussed at this level that is going to go towards determining your rights and what you can do in the future? I get it. People want to watch, something on TV, or they want to engage in a hobby. But, you, as part of a free society, it is not just your responsibility, but it is your obligation to the continuance of freedom for further generations for you to do your part and pull your own weight. And sometimes that means sitting your little butt down and reading a 37-page opinion about a particular instance that could actually eventually come up at some point in the Supreme Court, and also is a great jumping off point for the discussion of natural versus civil rights.